May it please.
Yes.
My lord, item number 2, my lord, it's a death sentence reference case, my lord.
Yes.
And, my lord, may I pray for fixing it in first week of August, my lord?
August.
Because it will take lot of time also, my lord.
Okay. If Mr. Kamal, you are amicus. Okay. Mr. Zaid Kamal, learned senior counsel in amicus in this state reference, and Ms. A. Begum, learned additional public prosecutor for the respondent state are present. So Mr. A.K. Bhuya, learned counsel for the appellant in criminal appeal number so 3, and for the respondent in the date reference has made a prayer to list the cases in the first week of August. Come on, post up. As the therefore listing is made with the consent of the learned counsel, learned amicus curiae, and learned additional public prosecutor for the state, list the cases made in the first week of August.
God bless you.
First week, no, second week of August. First week is only one date.
Come on, let it be.
Fourth, from fourth.
Fourth. Let it be on fourth, man.
No, will not fix.
Yes.
Fourth will fix.
God bless.
But I'm trying to listing this petition, my lord, the previous purpose, my lord. I filed it on last.
File before the registry.
Last Thursday, my lord, I filed, my lord, till date, my lord, not listed, my lord, for motion, my lord.
Ah.
Yeah.
When do you want?
Tomorrow, my lord.
When?
For tomorrow, my lord.
Okay.
God bless.
Please, Your Lordship.
I beg to mention item number 16 of the supplementary cause list.
Yes.
Lordship, Mr. R. Sharma could not come today as he has an ultrasound appointment today. He's suspecting of having a gallbladder stone.
Okay. Mr.
KJ Hazarika.
KJ
Hazarika.
Ajay, learned counsel appearing from Mr. R. Sharma, learned amicus curiae in 16, has submitted that Mr. Sharma is indisposed and has thus paid for listing of the case appeal on another date. Post of Ms. B. Priyal and senior counsel. Who is for in 17? Mr. Hazarika has submitted that he has taken consent from the learned amicus curiae for the appellant in 17. Ms. B. Priyal, the senior counsel and additional public prosecutor for the respondent state who is in attendance, has submitted that state has no objection to seek prayer.
After the holiday.
17 to একেলগে আছে না? Wait. Okay. Release the appeals immediately after the ensuing summer vacation.
Sir, I pray for listing of a one matter, my lord. I pray for listing of a one.
What matter?
It is a criminal appeal, my lord.
For what?
Already orders matter, already this honorable court has appointed one amicus curiae, my lord. So, my lord, the matter was last listed on 4th April, my lord. Till today, all the matter has not.
Aside you.
Yes, my lord. Deeply obliged.
May I please, Your Lordship? Your Lordship, I'd like to mention an listing of the matter of an IA criminal, Your Lordship.
Pursue before the registry.
Your Lordship.
Please, Your Lordship. I beg to mention item number 6, Lordship. I pray
Yes.
for an adjournment, Lordship. I've already circulated a adjournment.
You're Mr.
K. Kolita on behalf of A. Kolita.
Mr. K. Kulta, Learned Counsel, appearing on behalf of Mr. A. Kulta, Learned amicus curiae for appellant, has made a prayer for adjournment. A mention memo to that effect has also been circulated yesterday. Full stop. 10 years. Same B. Bhuya, huh? Who is in attendance? Who is in attendance? State has no objection, we'll put you after some vacation.
Dr. I beg to mention for listing of one IA in connection with criminal appeal number 220.
Also, we order registry.
Supplementary list for withdrawal. Item number 12.
Withdraw by you? Yes, for what reason you are withdrawing?
Your lordship, we want to withdraw the matter and file a fresh one, your lordship.
Hmm?
To file a fresh one, your lordship, in the trial.
File a fresh one.
Yes, your lordship.
You can ask by you. Bail নাকি? Seeking bail. Bail. Bail আছে। এই নিয়া। Bail application 2025. So bail final order has been passed or what?
No, your lordship. It has not been passed, your lordship. It's still on trial.
Miss
B. Soren,
B. Soren, learned counsel for the petitioner has submitted that appellant has submitted that the petitioner wants to withdraw the appeal. Come out with liberty. Close to Ms. L. Levy, learned Central Government Council for the respondent NIA. Who is it? President Kama has submitted that there is no objection from the respondent NIA regarding a prayer for withdrawal. So, in view of the above submission made by the Land Council for the appellant, the instant appeal is dismissed on withdrawal with liberty as paid for.
For orders. Items 13 to 15.
Yes, Ms. Bria.
Lordship, I have been relying on the evidence of PW 2, 3, and 4, along with the doctor's evidence, who was it is PW 11.
2, 3, and 4.
And PW 1 happens to be the wife of the victim. PW 2, his evidence is at page 25. my lord. His evidence is page 24. I know the accused Zakir Hussain, who is standing in the court today. I also see the absent accused Abdul Mazid,
Page 20.
24 of the compilation.
Oh,
whatever that
okay.
is. Who is standing in the court today. I also see the absent accused Abdul Mazid on last date in the court. Occurrence took place on last 10/12/2014 in between 8:30 to 9 p.m. At the time of occurrence, I, along with my friend, was going home after watching IPL match in the TV installed at a tea stall situated at Waitika, Tiniali. While we were going home on the way near a masjid and paddy mill, after crossing the Tiniali, saw one person pulling a thela and another person was accompanying with the thela. I then asked the thela puller what was kept in the thela, and then he replied that there were bricks in the thela wala. I saw one something was covered with blue colored triple. Being suspicious, I further started to interrogate him, and then the thela puller admitted that a dead body was kept in the thela. Thereafter, the person who accompanied the said Thelawala ran away from the place of occurrence and escaped while I caught hold of the Thela puller. Thereafter, I called the neighboring people and subsequently the people came there, apprehended Zakir Hussain from near the place of occurrence. On being interrogated, the said Thelawala took us to nearby abandoned house which belonged to some person at Ampi. Then, my lord. Thereafter, Abdul Batten informed police about the occurrence. Then PW2's further evidence. After the occurrence, I informed Abdul Batten about the incident. Abdul Batten informed police regarding the occurrence. Abdul Batten asked Asmat Ali from where the dead body was taken, but he stated that he did not know the name, but he could lead the house from where the dead body was taken. Thereafter, the Thelawala led us to the house of one Majid. Today, said Majid is standing in the dock. The people assembled there and started to create hue and cries. Subsequently, police also came to the spot. Thereafter, the dead body, along with Tela, one buckler, table, and gunny bags were handed over to police by village people. Police seized Tela, two gunny bags, and one buckler, triple preparing so and so. Then, Lordship's cross-examination, second line. The house where the Thelawala laid us is like a farmhouse. So far, I know no people live there. I do not know how the date of the disease was caused. I do not so and so. Lordship, that's how these three persons were Lordship.
No, Mojit was not there.
Majid was,
It is evidence.
yes, but thereafter, the residence belonged to the brother of the Masjid. And it has come up on evidence that on permission given by his brother, this one, Majid used to live there for some days.
From whom?
I'll be reciting your Lordship, I'll be stating. Then I have read PW2. Then PW2's further evidence page 26, my lord. Then PW3, your lordship. Page 28. He repeats the same thing, my lord. One was pulling and one was pushing, my lord. And first they have said, my lord, they were carrying bricks. And then when Sahidul tried to see what material was kept in a gunny bag, accused Zakir Hussain fled away. Sahidul called Asmat Ali. Then Sahidul told me that dead body was kept in the gunny bag in the thela. On being asked, accused Asmat told that he carried the dead body by the thela from the house of Abdul Majid. That's how Abdul Majid came to picture, man.
Which line?
Lordship, evidence of PW3.
3,
Lordship, I have
page 29.
Yes. Yes, 29, second line. The accused Asmat Ali told that he carried a dead body by the thela from the house of accused Abdul Majid. Then one third line. On being asked, the accused Asmat Ali led us to the house of accused Abdul Majid, situated at a little distance from the spot of at village Kuatika. Then cross-examination, second line. The house where the accused led us belonged to brother of Abdul Majid. Then further cross, second line. The persons who were pulling and pushing the thela were asked by us as to what was taken in the thela, and one of them replied a brick was carried there, but I could not specifically say who of the said two persons replied that answer. We could not ask accused Zakir Hussain anything about the occurrence because he fled away. Then I take your lordship to the evidence of PW3 line.
We are reading
Or
PW3.
PW4. PW4 is Abdul Batin. Then 5, 6, 7, 8 line, page 31, my lord. I saw Sahid detaining the thela while Asmat Ali was holding the thela and Zakir Hussain was standing behind him. Seeing me, Zakir Hussain fled away therefrom. Then next line, at that time many people assembled there and I asked Asmat Ali as to what was kept in the gunny bag carried by the thela. On being asked, Asmat Ali replied that the dead body was kept in the gunny bag and the same was carried by the tailor for throwing away the same. Then page 32, on being asked, Father Jakir could not say the name of the person in which house the said person is killed, but he told us that he would lead us to the house where the murder was occurred. Accordingly, on being led by Jakir, we turned the thela and went to the place where Jakir led us. Jakir thereafter went to the house of Majid and told us that the person was killed in that house. Thereafter, we informed police of Bisney PS over phone that a dead body was found in the gunny bag carrying by a thela. Accordingly, we handed over the said thela and gunny bag to the police. Police thereafter opened the gunny bag and recovered the dead body of a male person from inside the bag. Police took away the dead body with them and also seized the thela, 2 gunny bags and 1 tripal. Then next, next line, my lord, paragraph. After 2 days on being called by police, I went along with police to the house of Majid, and Majid produced 1 iron rod before police, admitting that by that rod he killed the deceased person. So that's how Lordship,
Before police.
yes. Like,
Admitting before police,
admitting
produced
before
one
police,
iron rod before police, admitting that by that rod, he had killed a deceased person.
admitting will not be there, but Lordship, he took out the weapon of offense.
This is how Majid came. So, these witnesses put the blame on Majid on the basis of statements of the 2 accused, Asmat and Zakir.
Jakir and page 33 also.
So that is how Majid came.
Yes. Page 33, Majid produced 1 iron rod before police, admitting that by that rod he killed the deceased. It is not a fact that I have not stated prior that police seized the said iron rod in my presence. And now I take your lordship to the evidence of doctor. Page 6.
Page,
Page 6. Page 6.
page,
Page 6. Injuries by law. Second column, between my law. Petechi seen on face. Pickle matter present on the under. So rigomortis is present and fully developed. A bruise of size so is present on anterior aspect of upper part of the nail. The area is bleached red and abraded. On dissection, ecchymosis, subcutaneous tissue and fusing of the underlying muscles seen. Then cause of death.
opinion. It goes with iron rod. It goes with iron rod.
This one, lordship, that potachi, that fact,
What potency, I don't know.
I have said, I have taken out it.
Potency seen on face.
Yes. Lordship, it may be caused due to beating.
Hmm? Then who strangulated? Majid said here, hit him with iron rod.
Lordship, there was no eyewitness to the occurrence then. But they were the part of, they has the conspiracy to kill
Potency.
the deceased man.
Where is potency?
On the front, Lordship on the top. Petechi symptoms, causes, treatment and prevention. This will taken out. Injuries. Any damage to the skin such as biting, heating or a car accident may cause petechi. It can also come due to friction against the skin due to carrying a heavy bag or a tight strap of cloth.
Damage to skin something biting.
They has the conspiracy in order to kill my lord, the victim. We ours they have taken.
How the trial court has brought Majid? We have seen Asmat. Appeal পুনরায় নিছিলেন হয়ে যেত। Oh, page
What-
59.
The accused led us to the place where the car was parked.
He has brought in the theory of res judicata
Yes.
against A1 on the basis of confessional statement of A2 and A3. Para 59. Res judicata comes also in case of accused or witness. Conduct of the accused, conduct of the accused by somebody, noticed by somebody.
Yes. But Lordship,
Conduct of the
possessions come
accused,
when the
if-
time.
if in
interval
the
is very
same
short.
transaction,
Yes.
it is to be seen by the accused, oh, sorry, witness, not by, ultimately, this is section 30, any constitutional statement. Section 30, Evidence Act. I did not kill. Majid killed. That is not admissible.
Implicating
If
himself
he
as-
says me and Majid both killed, then admissible. But I did not kill, Majid killed. Not admissible.
Lordship for entertaining a petition under 389 with a
See,
prima
it's in it
facie
also.
prima
You have heard, you
facie
I have heard.
material to grant a suspension sentence.
Indeed.
Lordship, evidence of PW 14 IO, Abdul Majid and Zakir Hussain went to someone to Puri village near NH. So and so, they showed me white Indica Vista. Leave it to Lordship.
Okay.
I thought that email it, cannot be necessary. Saju was still in
Saji,
conspiracy.
Saji. Where is the evidence of criminal conspiracy?
May not be the evidence.
And you have not,
All the evidence was in
public
April.
prosecutor did not press for 201 also. Mr. Chaudhary was very happy 201 was not there.
Not frame even now.
Huh?
Who's the one no air there?
No way there. So he was very happy with the trial.
Obliged to.
Regarding Asmat Ali, my lord, para number 72 is enough, ma'am. So, my lord, I don't think that my lord, further any submission needs to be made, ma'am. Highly officer.
Yes, Mr. Ahmed is there. Hey, Ahmed. Your item was there, no? 7? And how is there? Item 9. Okay, we'll take up the Pathar matter. Then your matter. Ahmed, 9 years, 6. It is 6 years and 9 years. 10 years to গুছি গ'ল। এইটো এজন হৈ গ'ল ন 10 years to। Mr. Chaudhary, you have 4 and 5.
Yes.
That will take some other day. We'll dictate another order now. One judgment.
Then your lordship may fix them in next week, my lord.
Next week, I'll be sitting in that justice, that bench,
Anytime next.
Honorable Justice, for 1 day or 2 days, maybe.
So this,
1 or 2 day.
this bench is not available, my
No,
lord.
that it is available, but
Your lordship,
will be attached to that bench for 1 day. Maybe it may spill over to second day, Tuesday and Wednesday, I'm told.
with your lordship, according to lordship convenience.
4 and 5. We'll find out a date. Right, we'll see the calendar,
Yes.
maybe after vacation.
Vacation, how it was 15. 15, my lord,
15.
Tuesday.
15 to note করে রাখা উচিত। 3 and 4 July. খুলিব।
14 reopening there.
নোট করে রাখা উচিত 15. Okay. Megha. Yes, you are supposed to make submission.
With my submit only point is statement regarding that 164 statement for that portion. Perhaps by the kindly use the 164 statement. We have missed one thing.
164 statement, okay. What you have missed?
Actually, we missed it.
Hmm?
Actually, we all missed it.
Mm-hmm.
Kindly come to page 59. Below portion. On essay. That both cannot be given in one. For recording 164.
No, have you seen the original one?
That.
Oh, I'm sorry. Oh, you mean oath? On oath. South, isn't it? Maybe in the type form.
I'll take.
Type form থাকিব পাৰে।
Getting that aspect, my lord, that form.
Huh?
That page 61, I mean, that portion, that memorandum portion. That last time you got it was trying to find out whether it should be written form or type or anything. These particular my lord, rule, I place it out. My lord. And in fact, my lord, whatever case law I have found, that only written that magistrate to put a memorandum. Whether it should be in a written form or typographical clause. that I
Okay,
have not
we'll
found.
leave it.
Yes, my lord. But
We'll
the
leave
thing
that
is
point. We'll leave that point.
Yes, madam, one thing is only that, madam, if suppose, madam, because apparently there is a form and regarding this form, basis is or aware recording the position, recording confession. If suppose a form has been provided to him, he's bound to record according to that form. If he didn't comply with that. another
What
way to
about 281?
Do it, madam. With that form. That,
Let's see. Even if he had missed that, he could have clarified in 463. That is not done. Constitution. And it is a statutory prescription,
yes.
right?
Here also this is on.
On oath. Nowadays, what is happening? What reasons for arrest,
And
grounds of arrest. Now it is a hot topic.
In fact, I argued regarding one point in my receipts, both my. If I need that.
So, do you know about the right to life and right to personal liberty under Article 21? Do you know about this Article 22 law regarding preventive detention?
22
And if a detainee is detained under any preventive law, then grounds of arrest are to be furnished to him.
Yes.
Then that has to be explained to him.
Yes.
If it is in English, it has to be translated by an interpreter. Then thereafter, it can be held to be compliant. 22(5). Right from 1950s onward, if a detainee is explained the grounds of arrest in a language not known to him, everything falls. Now see the language 281. So it appears to be a constitutional right. It is not the thing. It would be the constitution. Very illegal. Oh.
Regarding
See,
21(4).
if he does not understand the language in which it is written, shall be interpreted to him in a language which he understands. This is one part. Because only then he understands. Then the second part. He shall be at liberty to explain or add to his answers. So if he does not understand the language in which it is written, he is deprived of the opportunity to explain further. And yes, it is a curable 463. But even after 463, there is nothing. Then the court has to examine whether prejudice is caused or not. Miscarriage of justice. And if one part goes, everything goes. That goes. What it means is, so what is the motive? What is come?
Regarding.
If it, then you leave aside 164. Anything goes, everything goes.
Only regarding that.
Motive. It is a case of circumstantial evidence.
Only this regarding justice one or six, 21(4). To that, my reply was, because that is.
Because this man, PW1, this man has gone on explaining in cross-examination, which he did not know. See his story now. Victim went to the house of the accused. Accused asked the victim to wait, but the victim did not wait. All this story from he has got.
Regarding that effect, I only pointed out that they only matter that ROAC that he accepted.
Oh,
This portion, that accused.
which portion?
On page 16. Why I stated
Read
that-
over. But
Why I stated my 114E evidence.
100?
14E. Because if they are with it, they have to show that they didn't raise any question regarding that aspect.
This is presumption of fact. 115 is presumption of fact, not presumption of law. No.
Any case, whether if vote has been given, it is effective. itself. If vote has been given by recording foundation, if vote has been given by the vote, it is recorded. Otherwise, then
Yes, anything to add? Shortly and quickly.
Shortly, only one point only. The query that your Lordship had made regarding that memorandum, only on. Paragraph 7 and 14 will be relevant.
7.
Paragraph 5 says Exhibit 3 is the confessional statement.
7.
Paragraph 5, page number 3. Down below the page number is given, page 3. Paragraph 5. That so and so recorded the confessional statement, Exhibit 3.
Para?
5.
Ah.
Now, paragraph 6 says 164.4, the memorandum. It's quoted.
Produce. Produce.
If I may please paragraph 7. Lordship would go through paragraph 8 as well.
Paragraph?
8.
Hmm.
I'm relying on 7, 8, and 14.
7, 8.
And 14. 14 is at page number 7.
Azir Ahmed squarely covers some of this.
The Instant Criminal Appeal. From jail under section 383, Code of Criminal Procedure 1973 is preferred against accused.
PW 1 and 3, those circumstances regarding and plus recovery of weapon. And because there is no other person, I am hurting on section 3 of evidence act. And minor in circumstantial evidence, because failure to prove police from whether. I guess when I can give one judgment, but it's very near right now. And give it.
What is the reason for the accused confiding in PW1? Is a person of confidence?
They are neighbors. But
Against the judgment. An order dated 21/12/2020. Passed by the Court of Learned Sessions Judge Karbi Anglong at Diffu in Sessions case number 41 of 1998. By the judgment, an order dated 21/12/2020, the accused appellant has been convicted for the offense of murder under section 302, Indian Penal Code. And he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for further of rigorous imprisonment for 1 year. Post. It has been ordered that a period of detention already undergone by the accused appellant shall be set off under section 428, CRBC. The first information report was lodged before the officer in charge Diffu Police Station on 17/9/1994 by one Pramod Lele, LELE, as the informant, stating about an incident which occurred at around 8:30 p.m. on 16/9/1994. Postal. In the FIR, the informant had interiorly alleged that at around 8:30 p.m. on 16/9/1994, one Khogen Doimari, a cook in Gita Ashram, uh, uh, not literally, cook, was assaulted on head from behind by someone, and Khogen Doimari was admitted to Difu, his civil hospital, as there was the affair. Further mentioned that there was severe bleeding throughout the night. It further mentioned that Khogen Doimari was coming from a nearby village to Gita Ashram, and he was hit at a place just outside the boundary of the ashram. Para. On receipt of the FIR, the officer in charge, Difu Police Station registered the same as Difu Police Station case number 190/1994 under section 325, IPC. And thereafter, I entrusted the investigation to one Muhammad Badrul Islam, an officer attached to Difu Police Station at that time. Postal. The investigating officer, Muhammad Badrul Islam, within bracket PW5, on being entrusted with the investigation, proceeded to Difu Civil Hospital to question the injured, but he could not record the statement of the injured. Injured, reply, Khogen. But he could not record the statement of the injured as he was in an unconscious state. Thereafter, he proceeded to the place of occurrence for inspection and interrogation of the witnesses. It has emerged from the testimony of the IO PW 5, that he learned, on interrogating the witnesses, he learned that the accused appellant, within bracket, and after referred to as the appellant, person, had committed the incident. Full stop. Then, he went to the appellant's house situated nearby and seized a wooden Ural within bracket rice stamper. Rice stamper. Photo किया है. From his house by a CGR list, ext1. Post of the IO then apprehended the appellant and took him to the police station, where he was interrogated. Post of. Information was received in the meantime that the injured died at Deepu Civil Hospital. On 18/9/1994. Post of. The IO PW5 then proceeded to Deepu Civil Hospital and held inquest on the dead body of the deceased and prepared at Deepu Civil Hospital itself and prepared through the sub-divisional health officer, Deepu Civil Hospital. Post of the sub-divisional health officer, Deepu Civil Hospital, prepared an inquest report ext3, which was exhibited by the IO verified during his testimony before the court, which is signature therein. Post of. On 18/9/1994, the IO also made a prayer before the jurisdictional court to add section 302 IPC in Deepu Police Station case number 190/1994. Full stop. When the accused, when the appellant was forwarded to court after his arrest, on 18/9/1994 with a prayer to remand him to judicial custody. With prayers to remand him to judicial custody and to record his statement under section 164 CRPC. The court, a jurisdictional court on 18/9/1994 remanded the appellant to judicial custody and also, as per the prayer of the IO, for recording the statement of 164 CRPC, comma, the then additional deputy commissioner endorsed the matter to the
Page 54.
designation of CY.
Page 54.
24.
54.
To the magistrate to record the confessional statement of the appellant. When the appellant was produced from custody on 1992, sorry, no, I got to go. It line to Agon. When the appellant was produced from custody on 1994, the then additional district magistrate endorsed the matter to Mr. Z.R. Botha, Z. Botha, comma, magistrate to record Botha, huh? Botra, to record the confessional statement postal on receipt of the case record. Comma, the magistrate recorded the confessional statement of the appellant on 1994 itself. And thereafter send the case record to the trying magistrate by an order dated 1999 court. The IO, after collecting the confessional statement recorded under section 164 CRPC and the postmortem examination report, and completing investigation the case, comma, submitted SR sheets. Under section 173 to CRPC, right, SRC number 74/1994 on 30/11/1994, finding sufficient incriminating materials against the appellant for the offense under section 302 IPC. SRC.ext 4 করে দিন background. Post. Para. After submission of the charge sheet, comma, in connection with GR case, comma, police case number, Ipoh Police Station case number 190/2000 within bracket corresponding rear case number 479 1999 1994. Comma. The case records were forwarded by the additional district magistrate to the Court of Sessions by an order of commitment dated 18/9/1994 as the offense under section 302 IPC is exclusively triable by the Court of Sessions. Full stop. The learned additional public prosecutor was accordingly notified. Full stop. It was directed to the accused appellant to appear before the Court of Sessions on 20/10/1998. Full stop. Para. On receipt of the case records of GR case number so and so, comma, Sessions case number 41 of 1998 was registered. Full stop. On appearance of the appellant before the learned trial court of before the court of learned additional district magistrate, comma, Difu, comma, and after hearing the learned counsel for the parties, and upon perusal of the materials on record, comma, a charge under section 302 IPC was framed against the appellant on Hey, record the sound. On this. Stop. When a charge was read over and explained to the appellant, comma, he pleaded not guilty and claimed to be tried. Stop. The charge against the appellant was to the effect that at around 8:30 p.m. on 16/9/1994, comma, he intentionally caused the murder of Hogan Doimari, comma, a cook at Gita Ashram, comma, with a Ural at Gita Ashram. Para. During the course of the trial, comma, the prosecution side examined 6 number of witnesses And 7, number of documentary evidence, in addition to a material exhibit, a wooden Ural Mari as MET EXT1 poster. After closure of the evidence from the prosecution side, the appellant was examined under section 313 within bracket 1 within bracket B, CIPC. To 31/05/2002. In his reply, the appellant claimed the case to be a false one. Full stop. When the appellant was asked whether he would adduce any evidence in his support, he declined to adduce any defense evidence. Full stop. Thereafter, the learned trial court, after hearing the learned counsel for the parties and upon evaluation of the evidence of materials on record, proceeded to deliver the aforementioned judgment and order of conviction and sentence against the appellant. Postum. Hence, the present given appeal. Postum. We have heard Mr. V. Prasad, learned amicus curiae for the appellant, and Mr. R. Kosik, learned additional public prosecutor for the respondent state. Postum. Para, Mr. Prasad, learned amicus curiae appearing for the appellant, has submitted that the case of the prosecution is based on circumstantial evidence, as there was no eyewitness to the alleged incident of assault on the on Hogan Doimari on 16/9/1994. Post up. He has submitted that the prosecution has mainly relied on the confessional statement of the appellant recorded under section 164 CRPC within bracket EXT 6 and extrajudicial confessions allegedly made by the appellant before few of the prosecution witnesses. Full stop. The prosecution side has also relied on the recovery of an Ural Mari rice tamper to project the same as the weapon of assault. Full stop. It is his contention that neither the confessional statement EXC6 cannot be admitted into evidence in view of infraction of the statutory prescriptions contained in section 164 CRPC, read with section 281 CRPC. Post of it is his submission that the illegality, sorry, the procedural a violation in recording the statement, confidential statement of the appellant is not even curable under section 463 CRPC. Post. Further, the alleged extrajudicial confessions attributed to the appellant cannot be acted upon as the witnesses who deposed about such extrajudicial confessions testimony of the witnesses do not inspire any confidence to regard their testimony as trustworthy ones. Full stop. The recovery of the Uralmari rice sample, the manner of recovery of the Swensu was also doubtful. Full stop. It is his contention that neither the events have been established by the prosecution by cogent and reliable evidence resulting in several missing links in the chain of circumstances. Full stop. He has thus contended that the judgment and order of conviction and sentence is unsustainably low and is liable to be set aside. Full stop. Para. Au contraire, comma, Mr. Posickland, additional public prosecutor appearing for that state has submitted that the magistrate who recorded the confessional statement of the appellant deposed before the court as PW6, and from his testimony as well as from the confessional statement, comma, EXT6, comma, it would clearly emerge that there was no procedural violation in recording the confessional statement of the appellant. And as such, comma, the same can clearly be acted upon. There was recovery of an wooden Uralmari rice crusher from the house of the appellant, and the medical evidence was consistent with the said wooden Ural Mari as a weapon of assault. Full stop. There is no ground to disbelieve the testimony of the prosecution witnesses, who deposed about the making of extrajudicial confessions before them by the appellant. Full stop. As the prosecution side has been able, he has contended that as the prosecution side has been able to bring home the charge against the appellant, and there is no missing link in the chain of circumstances, the impugned judgment and order does not require any interference. Also, Para, we have given due consideration to the submissions of the land council for the parties and have a
Last time you know, say something from beginning, extrajudicial confession and then bring it back to trial. My intention is that, well, if even if it is rejected, the latest case, that can be like if necessary,
but that will require corroboration also.
corroboration. So
We'll deal with that. We'll deal with that. We have seen now, we know Aloknath Dotto.
This is Sakaram Shankar Ghosh.
Aloknath Dotto has dealt with all this in detail, maybe Sakaram also.
Sakaram.
Which year?
This is 1993.
2012, Aloknath.
For judgment.
Corroboration necessary, that is I'll hold. First is voluntary, second is true, and if it is retracted, it needs corroboration. Gone through the evidence took materials on record available in the case across associations, case number 41/1998 innovative. Full stop. As mentioned above, the prosecution side examined 6 number of prosecution witnesses. Full stop. However, the informant, Pramod Lele, who lodged the FIR EXT. FIR to exhibit was not exhibited, was not examined. Full stop. The FIR lodged by Pramod Lele on the basis of which the investigation was initiated was also not exhibited. By the prosecutor. No, I on page 60, 41. Was it exhibited? Find out from the record then.
Even in the judgment, the exhibits are listed, page 41.
I have seen that. But still, if
From the
anything
record.
on record, you find out. PW1 deposed to the effect that he knew the appellant, and at the relevant time, he was working as a teacher at Gita Ashram. As regards the incident, PW1 stated that the incident occurred on 16/9/1994, and on that day, after having meal, he went to bed at around 8:30 p.m. full stop. At that point, he heard a voice calling, quote, Ashram Buddha, page 7, unquote. Having heard the voice, he went out of his house. Full stop. PW once deposed that at that point, the appellant came to him to tell that the appellant had killed Ashram Buddha, that is, Khogen Doimari, who was a cook at Gita Ashram. Full stop. PW once further deposed that he was told by the appellant that the disease was killed. LED, killed, with an Ural Mari on the road heading towards Gita Ashram. Full stop. Then he informed the matter to the superintendent of the hostel, Pramod Lele. And Pramod Lele came along with some local boys, and all of them went to the spot. Full stop. With him means whom? Pramod Lele or PW1? The accused was also present. That is also a factor. He was all along with them. The accused was also present with them. Full stop. They found Khogen Doimari lying on the ground with an injury on his head, and they saw blood oozing out from the injured part. Full stop. PW1 further stated that the appellant explained that he had killed with the oral mari. Full stop. Then, they took Khogen Doimari to hospital for treatment. Full stop. PW1 further stated that after waiting for 2-3 hours, he left the hospital, and it was on the next day, he heard that Khogen Doimari had died. Full stop. The appellant stayed at his home. At his home, full stop. In the meantime, Pramod Lele lost the affair and police personnel came for investigation and arrested the appellant, who confessed his guilt before the police person. Full stop. The Ural Mari was brought to before the police person, and the police seized it. Virali once stated that he did not sign the seizure list. So, however, he identified. I know. He identifies police before the court. In cross-examination, PW1 stated that the accused used to reside in a quarter near their school. Full stop. He was not aware of any kind of quarrel between the appellant and the deceased. Full stop. He further deposed that the victim went to the house of the appellant. Yes, eligible. Soup লৈ আছিল. What will be? That is it. That is written in Assamese only. That the translator illegible. Soup লৈ আছিল.
Hiding.
And soup to কি ক'ব?
So, considering this,
Soup.
basically, my lord, literal word will be for the case.
Find out in the meantime, concealed and kept himself concealed there. Concealed to the word soup. Soup লৈ আছিল. আমাৰ আছিল নহয় ওলাই থাকক কনচিলটো বল কৰি ৰাখিব. Then the appellant asked the victim to wait, but the victim did not wait. Then the appellant followed the victim and killed the victim as if the victim was a child lifter. Full stop. PW stated that at the relevant time, there was rumor about child lifter in and around Diffu. Full stop. PW1 supposed that the incident was accidental and had the victim Been not silly. Hey, silly. Yeah. Yeah. Had the victim been not concealing himself in the house of the appellant at night, the incident could not have occurred. Full stop. He further deposed that the appellant Hmm. did not kill. Victim was not killed voluntarily. Full stop. Para. PW2 deposed that he knew the appellant as the appellant was related to him. And he also knew the deceased, who was a cook at Gita Ashram. Full stop. As regards the incident, PW2 deposed to the effect that the incident occurred before Gita Ashram at a place before, in front of the Gita Ashram. Full stop. At the relevant time, he was sleeping in his house and hearing noise, he went out of his house and proceeded to the spot. Full stop. There was a gathering of people and he found Hogan Remery lying on the ground, sustaining an injury on his head. Full stop. He saw blood coming out, oozing out of the injury. Full stop. He found that the appellant was also present at the spot and he told him that the disease was killed by him. He told her, and the appellant told him that appellant had killed the disease with an Uralmari. The disease was taken to the hospital for further treatment, but he did not stay at the hospital. Full stop. It was on the next day, he heard that Hogan Doimari had died. Full stop. He came to the hospital and also went to the police station on that day. The appellant was in his residence. Full stop. The Uralmari was brought by the appellant and the same was seized by the police. Full stop. He identified the Uralmari as Matty XT1 and exhibited the seizure list as EXT1, which is thumb impression therein as EXT or thumb impression therein. Post. Crossing keys. He further stated that he did not see the incident and he had heard about it only after the occurrence. He further stated that the appellant did not come to the hospital at night on that day. Poster. He further stated that the appellant thought Khogen Doemari as a side lifter and did not kill intentionally. Poster. Para. PW3. Stated that the appellant, he knew the appellant who used to reside near Gita Ashram. Post op. He knew Khogen Doemari as a cook at Gita Ashram. Post op. PW3 deposed that Khogen Doemari was killed by the appellant in an incident occurred at around 7 p.m. And he was informed by other members that Khogen Doemari was assaulted. Post op. On the next day, Khogen Doemari died, and it was informed to him by the members. Post op. He went to the hospital along with one Vipun Hazarika, within bracket, not a witness. The police, no, sorry, the IO called came to Gita Ashram and called the persons to ask about the person who had killed Khogen Doemari. At that time, the appellant was also called by the IO. And there, he confessed before the IO that he had killed Khogen Doemari. The accused appellant told the police that the disease was killed by a lathi as he was roaming nearby after cooking the meal. Pusto. Pera. PW4 was serving as medical and health officer, -1, at Dibhu Civil Hospital on 17/9/1994. So on 17/9/1994, he testified that on 17/9/1994, he performed post-mortem examination on the dead body of the deceased. And on examination of the dead body, he found the following. Page 14. When cross-examined, comma, PW4 testified that the injuries sustained by the deceased on his person can be sustained on falling on hard surface from a high place. Para. PW6 was the magistrate who recorded the confessional statement of the appellant on 1994. Full stop. PW6 testified about the manner in which he had recorded a confessional statement of the appellant in connection with Difu Police Station case number 190/1994. Under section 325, registered under section 325 IBC. Postal. He exhibited an order passed by the additional district magistrate as EXT5, whereby he was authorized, the case record was endorsed to him for recording the confessional statement of the appellant. Posto. He exhibited the confessional statement of the appellant as EXT6 and his signatures therein as EXT61 to EXT66. Full stop. He also exhibited an order dated 1994, which he had passed EXT 7. EXT 7, whereby he forwarded the case records to the trying magistrate after recording the confessional statement of the appellant. PW6 did not, however, exhibit the signatures, stroke thumb impressions of the appellant in the confessional statement, comma, EXT6. The testimony of PW6 as regards the manner in which he had recorded the confessional statement of the appellant would be adverted to in the later part of the order when we consider the acceptability, its acceptability. Para. From an analysis of the testimony of the prosecution witnesses, comma, it has emerged that it was mainly the prosecution witnesses, comma, PW1, comma, PW2 and PW3 who deposed about the deposed about the extrajudicial confession purportedly made by the appellant before them. Full stop. As regards the confessional statement, it was PW6 who testified about it. Full stop. From the testimony of the autopsy doctor, PW4, it can be noticed that there was multiple cranial bone fracture. Full stop. There was presence of depression in right temporal bone and parietal bone. Full stop. Hematoma was present in the temporal bone and intracranial hematoma was present over the parietal lobe and temporal lobe, where page 14. Full stop. The death of the disease was due to shock and hemorrhage as a result of intracranial injury, and the injuries were found to be antemortem in nature. Full stop. At the same time, the autopsy doctor had opined that the injuries sustained by the deceased could be possible to sustain if the person falls on hard surface from a high place. Full stop. Para. Para not copy. When the appellant was examined under section 3131B CRPC, his plea was clear denial So his denial was also he had also denied about making extrajudicial confession and a judicial confession. Full stop. Thus, because of the appellant's such denial at the stage of 313 CRPC, the extrajudicial confession and the judicial confession, purportedly made by the appellant during the stage of investigation, had become retracted extrajudicial confession and retracted judicial confession. First of, it is contended by the learned additional public prosecutor that such retraction was a belated one. The Indian Evidence Act 1872. We didn't make the Evidence Act for sure. Has made confession on the part of an accused admissible in evidence and it can be acted upon. Full stop. Confession generally, ordinarily, comma, can be of two categories, comma, namely, comma, one, extrajudicial confession, and two, judicial confession. The confession which is made by an accused or a person suspected of committing a crime, comma, ordinarily before a person or persons are considered to be extrajudicial confession. The confession which is made before a magistrate or a court in the course of judicial proceeding is termed as judicial confession. Post. Para. The choice ডাস্টবিন লাগিছে জয় চন্দ্র এই 2000 না ইয়াতে নাই ধনঞ্জয় 2001 4 SSC 9 Before considering the issue of admissibility or other inadmissibility of the statement of the appellant recorded under section 164 CRPC within bracket EXT6, comma, it would be appropriate to refer to the relevant provisions governing the procedure of recording of confessions and statements, comma, as contained in section 164, comma, CRPC and section 281, comma, CRPC. For the purpose of issue raised herein, comma, the provisions containing section 164. And 280. And section 281 CRPC are found to be of relevance and import. Full stop. Section 164 within bracket 4 and section 281 within bracket 4. And the same are quoted herein for ready reference. Subsection 4 of section 164 has inter alia prescribed that a confession shall be recorded in a manner provided in section 281 for recording the examination of an accused person and shall be signed by the person making the confession. And the magistrate shall make a memorandum at the foot of such record as provided thereunder. Subsection 4 of section 281 contained a 281 3 would লিখিব 4 লিখিব Subsection 3 of section 281 CRPC contains a mandate that the record shall, comma, if practicable, comma, be in the language in which the accused is examined, or, comma, if that is not practicable, in the language of the court. Subsection 4 of section 281 CRPC contains a prescription that the record shall be shown or read to the accused, comma, or, comma, if he does not understand the language in which it is written, comma, shall be interpreted to him in a language with which he understands, comma, and he shall be at liberty to explain or add to his answers. Subsection 5 quote kori. Section 285, 281(5) has the mandate that the record shall thereafter be signed by the accused and by the magistrate or presiding judge, comma, who shall certify under his own hand that the examination was taken in his presence and hearing, and that the record contains a full and true account of the statement made by the accused. Para. As already stated above, as already found from the discussion made above. No, it is already found from the discussion. It is found from the discussion made above, comma, the 16, 17, the appellant was taken into custody and thereafter, arrested on 17/9/2000, 1994. Full stop. Oh, 17 or no, 17, no, arrested on 18. Full stop. The appellant was 18, 18, 18, 18, right?
18 he was produced before.
No. 17, it was lodged.
17
FIR was
morning it was
lodged.
He went
At
to the
that time, it
hospital,
was 325.
325. He went to the hospital, came back, interrogated him. And then he came to know that the patient died, victim died. And at that moment, he arrested him.
15 more.
Hmm?
On
18. And when he was produced,
On 18.
15.
arrested what? 18. I think arrested on 18. Oh, produced also.
Police also on it.
Oh,
Then there was.
on 18/9 to 1994 itself, the accused appellant was forwarded before forwarded was produced before the jurisdictional court, and on being so forwarded and produced, the appellant was remanded to custody.
17 arrested, 18 remanded.
Okay, 17 arrested
18 remanded.
on 18, huh? That was up next. 18, first up. On 18/9/1994, the IO made a prayer for recording the confession statement of the appellant. Full stop. On 1994, the additional district magistrate by his order dated 1994 within bracket EXT5 endorsed the case record to the magistrate, PW6 to record the confessional statement of the appellant. Full stop. The confessional statement of the appellant was recorded by the by the magistrate, EXT. PW6 on 1994 itself. Full stop. Therefore, it is relevant to examine the testimony of PW6 at this stage. Full stop. Para. In his testimony, PW6 deposed that pursuant to the order dated 19/9/1994 in bracket EXT5, the case records and the appellant were produced before him. Also, accordingly, he explained the matter of confession to the appellant and also cautioned him that PW6 was not a police officer but a magistrate. Full stop. The appellant was told by him that he was not bound to give any confessional statement, but if he did so, it might be used as evidence against him. Postal. PW6 further stated that thereafter, the appellant was given 3 hours time for reflection. Postal. During the reflection period, the appellant was kept in an adjacent room under the supervision of a peon. Postal. On completion of the reflection period, the appellant was again produced before him for recording the confessional statement. Postal. PW6 further testified that he again explained the matter of confession to the appellant and also cautioned him that he was not bound to give confessional statement. Postal. PW6 stated to have explained the necessary requirements for the appellant before recording the confessional statement. Postal. PW6 further deposed that in spite of cautioning the appellant intended to give the confessional statement voluntarily. Postal. Finding the appellant ready to give confessional statement voluntarily, he proceeded to record the confessional statement. Postal. After completing the recording of the confessional statement, PW6 gave a certificate stating that the confession was voluntarily made and it was taken in his presence. After recording the confessional statement, he sent the case record to the original court. During cross-examination, PwC admitted that he did not mention the name of the police officer, who brought the appellant before him. In his order, within bracket EXC7. In the confessional statement, EXC6, he had mentioned that he recorded the confessional statement at 3 p.m. after expiry of 3 hours, which was given for reflection. He did not mention the name of the peon. In his order, within EXC7, under whose supervision the appellant was kept in an adjacent room for reflection. He also did not mention in the order EXC7 that the appellant was kept in an adjacent room for reflection. Para. recording of confession of an accused under section 164 of the code is considered to be a very solemn act. To stop. It has been repeatedly observed that in discharging his duties under section 164, CRPC, the magistrate must take care to ensure that the procedures prescribed in section 164 of the code 164 and section 281 of the code are fully adhered to. So the magistrate has to fully satisfy himself that the confessional statement which the accused wants to make is in fact and in substance voluntary. Full stop. Para. When taking into the prescriptions contained in section 164 4 CRPC, subsection 4 of section 164 CRPC and subsections 3, 4, and 5 of section 281 CRPC. In mind command, the confessional statement EXT6 of the appellant and the testimony of the magistrate, recording magistrate, PW6 are examined, it has emerged that the it has emerged that the appellant during the stage of had only sorry, the only sorry, only thumb impressions of the appellant were obtained in the records of the case by the recording magistrate, and there was no signature of the appellant. Full stop. They will come back. Have a reading. Después el lengua, miren inglés. One. He has not spoken anything about the languages. The possible conclusion that can be drawn from the thumb impression is that the appellant is an illiterate person. Most of the appellant is definitely convergent, which is most of the recording magistrate had recorded the entire confession statement of the appellant in English language. Full stop. The prescription containing amended is prescribed in subsection 4 of section 281 to the effect that if the accused does not understand the language in which it is written, comma, then it shall be interpreted to him in a language which he understands. Full stop. There is no recollection either in the records pertaining to the confessional statement EEXT 6 that the recording magistrate had interpreted the questions, the questions and answers he had written in a record, and the confessional statement he had recorded in a language understood by the accused appellant. Full stop. Has been provided in section 463. CRPC of the code. No, section 463 of the code has dealt with a situation, has dealt with situations for non-compliance. In case of non-compliance with the provisions contained in section 164 or section 281 of the code. First up, if any court before which, लिखी दी वो। Subsection 2 of section 43 has made the provision applicable also to the course of appeal, reference and revision. Full stop. Para. If the court comes to a finding that no, in Dhananjaya Reddy versus State of Karnataka, reported in 2001 for SSC 9, the necessity to comply with all the provisions of section 164 CRPC, more particularly, subsection 4 thereof, and the conditions prescribed in subsection 5 of section 281. And the consequence of non-compliance of those provisions and conditions came up for consideration. Also. It has in the non-compliance alleged therein was with regard to non-signing of the confessional statement by the accused. Full stop. It has been observed to the fact that besides ensuring that the confessional statement being made before him is voluntary and without pressure, the magistrate must record the confession in the manner laid down by the section. Underline clearly. Omission to comply with the mandatory provisions, one of such being as incorporated in subsection 4 of section 164 is likely to render the confessional statement inadmissible. Full stop. The words quote shall be signed by the person making the confession, unquote, are mandatory in nature, and a magistrate recording the confession has no option. Mere failure to get the signature of the person making the confession may not be very material if the making of such statement is not disputed by the accused, but in cases where the making of the statement itself is in controversy, the omission to get the signature is fatal. Honorable Supreme Court has gone on to observe that has gone on to hold that compliance with subsection 4 of section 164 of the code is mandatory, and its non-compliance renders the confession not admissible or reliable. It has been held to be a subtle position of law that if a part of confession is excluded under any provision of law, the entire confessional statement in all its parts, including the admission of minor incriminating facts, must be excluded unless proof of it is permitted by some other section, such as Section 27 of the Evidence Act. Full stop. The Honorable Supreme Court in Kehar Singh versus State within Delhi Administration, 1988 3 SCC, has held that the compliance with subsection 2 of section 164 being mandatory and imperative, its non-compliance renders the confession inadmissible in evidence. In the Honorable Court has approved The decision in Nazir Ahmed versus King Emperor, AI 1936 BC, 253 within bracket 2. Wherein it was held that if a statute has conferred a power to do an act and has laid down the method in which that power has to be exercised, it necessarily prohibits the doing of the act in any other manner than that which has been prescribed. Full stop. The magistrate, a magistrate, therefore, cannot in the course of investigation record a confession except in the manner laid down in section 164 of the code. Full stop. Para. The recording magistrate, PW6 did not make any mention in what manner the mandate contained in subsection 4 of section 281 of the code was complied with. Full stop. For compliance of the said mandate, he had the obligation to interpret to the appellant the contents of the confessional statement in a language which the appellant understands, since he had recorded the confessional statement in English. Full stop. The question of curing, making it curable under section 463 CRPC would not arise because after interpretation of the contents of the confessional statement, to the appellant in a language the accused understands, the accused has a liberty thereafter also to explain or to add to his answers. Full stop. Such a right can be availed by the accused only after interpretation of his previous statements, which has been recorded in a language not understood by him, not conversant or understood by him, in a language he understands. Full stop. In the event, the condition precedent of interpretation in a language, interpretation of the confessional statement in a language with which the accused is conversant or understood by him, comma, the accused could not avail the opportunity. The accused is prevented from the opportunity to either to explain or to add to his answers. Full stop. Therefore, comma, in the event of failure to interpret, in the event of failure on the part of the trying magistrate to interpret the records in a language understood by accused, comma, the same would clearly amount to miscarriage of justice. Full stop. And such a miscarriage, as such non-compliance goes to the root of the matter and cannot be cured under the provisions of 463 CRPC. Full stop. As a result, comma, we are of the clear view that non-compliance of the mandate contained in subsection 4 of section 164 and subsection 4 of section 281 of the code, comma, which is mandatory, comma, has rendered the confession purportedly made by the appellant comma, inadmissible. Full stop. In view of the settled position of law that if a part of the confession is excluded under any provision of law, comma, the entire confessional statement in all its parts must be excluded. And we hold so in respect of the confessional statements EXC6 involved in this case. Para, Google it. Para. It is true that an extrajudicial confession, comma, if voluntary and true, and made in a fit state of mind, comma, can be relied upon by the court. A confession will have to be proved like any other fact. The value of the evidence as to confession, comma, like any other evidence, comma, depends upon the veracity of the witness to whom it has been made. So the value of the evidence as to the confession depends on the reliability of the witness who gives the evidence. Full stop. It depends upon depends on the nature of the circumstances, comma, the time when the confession was made, and the credibility of the witnesses who speak to such a confession. It can be acted upon if the words spoken to by the witness are clear, comma, unambiguous, and unmistakably convey that the accused is the perpetrator of the crime and nothing. Is omitted by the witness which may militate against him. After subjecting the evidence of the witness to a rigorous test on the touchstone of credibility, comma, the extrajudicial confession can be accepted. এই প্যারাটা লিখে দিব প্যারা 4 লিখে দিব Reverting back to the facts of the case. It is found that on a closer scrutiny of the testimony of PW3 that he was not the person before whom the appellant had confided anything. As regards the assault on the deceased. Full stop. PW3 appeared to have gathered the knowledge only from some other members. Full stop. The two prosecution witnesses, PW1 and PW2, had testified that the appellant had made confessions to them individually. Full stop. From the testimony of PW1, it would emerge that he was the first person before whom the appellant had made the confession. Full stop. According to PW2, the accused made the confession before him. Only at the place where Khoghen Demarie was found lying on the ground, sustaining an injury on the hand, and many persons assembled around him. Full stop. When the testimony of PW1 is looked at in entirety, it is noticed that PW1 had gone on to make embellishments by deposing about the manner and the reason for which the appellant had assaulted Khoghen Demarie when only confession that was allegedly made by the appellant to him was about killing of Khoghen Demarie by an Uralmari. Full stop. That it has emerged from the evidence on record. It has emerged from the, emerged from the testimony of PW1 that there was no animosity, prior animosity between the appellant and the deceased. Full stop. The veracity of, as regards the extrajudicial confession allegedly made by the appellant before PW1 and PW2 is also to be tested with the truthful nature of the confession. Posted. Both PW1 and PW2 testified to the effect that appellant confessed before them separately that he had killed the deceased of Khoghen Doimari. Whereas at that time, when such confession was allegedly made, Khoghen Doimari was alive and not killed. Post stop. Khoghen Doimari at that point of time was only lying injured with an injury on the head. Full stop. It has not emerged from the evidence on record that these two witnesses, PW1 and PW2, were close confidant of the appellant, before whom the appellant could easily confide. Full stop. The recovery of an Uralmari cannot be held to be a circumstance in the chain of circumstances unless in the absence of further evidence that the oral Mari was used in the absence of well, corroborative reliable evidence that the oral Mari was used in assaulting, in injuring, assaulting Khoghen Doimari on the date of the incident. Full stop. Conspicuously, comma, the length and breadth of the Ural Mari rice tamper, wooden Ural Mari rice tamper, were not mentioned in the seizure list, comma, EXT1. Full stop. While PW1 deposed to the effect that the Ural Mari was brought to police. He did not mention who had brought it to the police. Full stop. On the other hand, comma, PW2 deposed that Ural Mari was brought to the police personnel by the appellant. It was then seized by the police. Full stop. Para. The prosecution has not brought any evidence on record that at any point of time, point of time prior to the incident, comma, the appellant and the deceased were seen together. Full stop. The conduct of the appellant at a time in and around the time when Khoghen Doimari was lying injured at a public place also assumes significance. Full stop. From the testimony of the prosecution witnesses, comma, more particularly, comma, PW1 and PW2, it has emerged that the appellant was with them and near the injured, Khoghen Doimari on 16/9/1994. 1994. It is a it cannot uh, other a rice tamper is ordinarily available, is a tool. Is a rice tamper is a tool which is ordinarily available in a household, and as such, mere recovery of a rice tamper from the house, either from the house of the accused or being handed over by the accused, cannot be alone cannot be an incriminating circumstance against the appellant. এইটো আগৰ খিনি সোমাই দিব হা the presence of though it is true that it is right, it is right. It is right to say that mere abscondence of an accused does not lead to a firm conclusion about his guilty mind, about his involvement in a crime. So similarly, mere presence of an accused also does not lead to a firm conclusion about his non-involvement in the crime. Full stop. Yet, the appellant's presence with the other persons near the injured and his subsequent presence in his house even after the death of the deceased is a fact, which is to be taken into consideration along with the other facts and circumstances. Full stop. The motive for commission of an offense assumes greater significance in cases based on circumstantial evidence than the cases based on direct evidence. So it is true that failure to prove motive in cases resting on circumstantial evidence is not fatal by itself, and at the same time, absence of motive in a case based on circumstantial evidence is a factor which weighs in favor of the accused. Full stop. In the case in hand, the prosecution side has not been able to establish such facts wherefrom a motive for the accused to commit the offense could be reasonably inferred, and the same becomes an additional missing link in the chain of circumstances. Full stop. The prosecution has failed to establish anything wherefrom it can be inferred that by committing the offense of by committing the act, the appellant would gain anything. Full stop. From the medical evidence in the form of testimony of the autopsy Dr. P.W. 4 or 5. Four, 5, Dr. 2. Four. And the PME report EXT2. It has not cleansingly emerged that the death of the disease had resulted from an act of homicide Full stop. The injuries sustained by the disease on his person were possible to be sustained also by falling on hard substance surface from a high place. Full stop. Para. It is it has been held by a three-judge bench of the Honorable Supreme Court in Ramakant alias Nanlal Bharti versus State of Uttar Pradesh, 2022, 5 SCR 162. After analyzing, after considering all a number of decisions on extrajudicial confession in Goidim. It has been in as considered as resonance post. After considering all the important precedents, comma, it has been held to be well settled that it is held that it is held, comma, in sum and substance, comma, that an extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with great deal of care and caution. Where an extrajudicial confession is surrounded by suspicious circumstances, comma, its credibility becomes doubtful and it loses its importance. Full stop. A court generally, comma, has to look for independent, reliable corroboration before placing any reliance upon an extrajudicial confession. Full stop. Para. Really, suspicion, it was suspicion. Suspicion of error. Suspicion. Or scene of circumstance. Of mining. In a light of the discussion made above and for the regions assigned hearing, more particular, comma, in view of a number of missing links in the chain of circumstances we do not, we find ourselves in disagreement with the finding of guilt arrived at by the learned trial court. Full stop. In in criminal, in administration of criminal justice, it is a golden principle that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. Most of this principle has a special relevance in cases where the guilt of the accused is sought to be established by the circumstantial evidence. Full stop. As the prosecution has failed to prove its case against the appellant beyond all reasonable doubts by way of clear, reliable, credible, and unimpeachable evidence, we find that the judgment and order of dated so-and-so of conviction and sentence passed by the learned trial court are sustained in law, and the same is liable to be set aside. Most of it is accordingly set aside. Most of the consequently the criminal appeal is allowed. First of the accused appellant is to be released from custody forthwith if his custody is not required in connection in connection with any other case or for any other purpose. First of, before parting with the record, appreciation, prasad, the records of the trial court are to be sent back forthwith. Your completion definition listen again. We reiterate the observation, direction, the recommendation made by the learned court, trial court regarding compensation, regarding disbursement of compensation to the next kith and kin of the deceased under section 357A, CRPC.
In the initial third or fourth paragraph, you also had the charge framing date, you also had left it blank. It is 31/5/2002.
31.
And the FIR was not executed.
I already recorded.
And then the, while translating Uralmari, it was stated that it is tamper or crusher,
Rice tamper.
but the appropriate term is pestle, mortar pestle,
Mortar.
pestle, P-E-S-T-L-E.
I have
Wooden,
seen
wooden pestle.
what is rice tamper. I have seen photograph also. Correct. Not wrong.
Not wrong. But pestle
I don't
is
know
also
correct, but not wrong.
not wrong. Oblige.
Where is Mr. Ahmed? Yes, Mr. Hassan. Waiting. Mr. Hassan and Mr. Thor, some physical discomfort on the part of my esteemed sister. Otherwise, I could have taken. Actually, at 2:30, 10:30 itself, I have asked for your presence. Tomorrow? Please, I guess tomorrow. Possible, we'll take up immediately after the other matters. হয়ে যাবে একটু ফাস্ট বারোটার বাজার হয়ে যাবে ইউ আর দেয়ার প্রিন্সিপাল অফ ল
I have taken such judgment.
কিমান আছে
Nine.
Otherwise, I would have taken it today. Because 9 years, Mr. Kaushik, you have to come up with strong case. On the same set of evidence. One mystery and one Jugali.
Yes, mystery has been acquitted.
Mystery has been acquitted. Jugali is behind the bar for last 9 years. Only for the fact that he preferred the appeal after several years. So whether principle of parity would apply or would not apply. The coordinate bench has already acquitted. How many years back?
That's 2019.
2019. So 2019, on the same set of evidence, he is behind the bar. So one day in detention itself is not proper. That is why I am giving priority to this. So you come up whether principle of parity would apply or not. The coordinate bench has already analyzed everything. But still you have to analyze.
Gone through the evidences and all, same orders.